Okay, well, I think with that, we'll probably get going. So good morning, everyone. I am Chris Brennan. I'm a legal director here at Gowling. And I'm joined today by Simon Harris, who is a senior associate in my same team, the commercial team. And we both, for our sins, specialised to one degree or another in public procurement. I'm a legal director and also a procurement professional support lawyer. And we're here this morning to deliver a session on rooting out fraud and corruption. Now, it's a big topic, and there's quite a lot, all in all, that we could probably say about this topic. So with our procurement hats on, we've decided that we're actually going to concentrate today on rooting out fraud and corruption in the context of public procurement. So it's very much done with a kind of a procurement hat on, if you like. And with that in mind, we've chosen these as our topics. First of all, I'm going to set some context to why rooting out fraud and corruption is, well, basically really important when it comes to proper public procurement. Simon is then going to wade in and talk about grounds for exclusion in procurement processes, what the procurement regime, the rules have to say about rooting out fraud and corruption in that particular arena. He's then going to talk a little bit about conflicts of interest. I will then pick up again with a quick canter through bribery, and also saying a little bit about sanctions, notably the sanctions against Russia, because even though perhaps that might go a little bit beyond fraud and corruption, in the strict sense, it's probably quite an opportune time to pick it up as a sort of an allied topic. I also then say a little bit about procurement in the pandemic and some of the interesting issues that threw up in this same space. Simon will then look at fraud and corruption procurement bill, and will talk us through some tools to help root out mischief. So on a practical level, once we've said everything we're going to say, what are the things that we can all do, on the ground, as it were, to help root out and eliminate fraud and corruption from procurement processes. So that's our agenda for this morning. Okay. So first of all, a bit of context. And I think the first thing to say is that quite a lot has been written on fraud and corruption when it comes to public procurement. And it's worth bearing in mind, I suppose, first of all, what procurement is. So it's government purchasing of goods and services, and indeed big construction projects, or construction projects big and small. And it's very big business. Now, as a publication put out in 2016 by the OECD said, the total volume of public procurement, which is the government activity of purchasing goods, services, and works, accounted for 12% of GDP and 29% of general government expenditure in OECD countries, amounting to 4.2 trillion euro in 2013. Now, obviously, those figures are a few years old, but I'm sure it won't have changed that much in the intervening period. And indeed, there is plenty of data from more recently that I think would back that up. What does this mean then? Well, it actually means that public procurement as a thing can be particularly vulnerable to corruption. Why is that? Well, because obviously a lot of procurement happens. There are lots and lots of transactions, lots of government procurement transactions throughout the UK, Europe, and the world. High financial stakes. Contracts are often worth many millions, sometimes billions of pounds apiece. Process complexities. Anyone who has tried to run a procurement process will know that procurement processes can be complex to put together and then to run. There is close interaction between officials and businesses. That's why we have procurement portals and special channels of communication, really in order to try and ensure that all communication between a contracting authority, the government procurer, and the bidder, the business tendering, is through the proper channel. And of course, numerous other stakeholders. And of course, the money spent on public procurement ultimately is public money. It comes from you and me. And so we've all got a keen interest in ensuring that procurement processes are kept clean of fraud and corruption. Now, when corruption rears its head, it's probably true to say that the results of any public procurement exercise just generally tend to be less good. Contracts might be more expensive, might be considerably more expensive, or the services or products which are delivered under those contracts might not be as good. And again, quoting the OECD, its foreign bribery report from 2014 provides additional evidence that public procurement is vulnerable to corruption. That report said more than half of foreign bribery cases occurred to obtain a public procurement contract. Okay, so that comes from the same source as the quote in the previous slide. So it's telling that this happens and that there's a lot of focus on it. Now, the most active sectors, again, quoting the same source or citing the same source, are these: mining, extractive, oil and gas, construction, transportation and storage, and also IT and ICT, information and communication technology. It seems that those sectors are perhaps at risk of being particularly susceptible, for whatever reason, to fraud and corruption. I'm sure it's not exclusively those, but those sectors have been cited as perhaps being particularly susceptible to it. Now, there can be a lot of different types of behaviour which we can perhaps package into the fraud and corruption box, if you like, when it comes to procurement. And any number of these sorts of behaviours can manifest corruption in a procurement stage, in a procurement process, and they can happen at different stages of a project or a process. So, at the procurement stage, or indeed before it, any of these could happen. So there could be bribery, there could be giving bribes, there could be acceptance of bribes, and for contracts with a foreign field of bidders or an overseas or transnational field of bidders, bribing foreign public officials. Bid rigging, collusive tendering is another big one. That can take the form of behaviour such as market sharing, which is where a particular business says, I will bid or I will deliver contracts in this area or in this part of the market if you deliver them in another area of the country or of the market and keep off our respective territories. Price fixing. So that is an agreement between competitors. It's a horizontal agreement to fix the prices at which goods and services are delivered or at which works are delivered. And again, the aim there is to keep prices artificially high. Bid rotation, where bidders take it in turns to bid or not bid for particular opportunities, is another form of collusive tendering. Cover pricing, that's where business A suggests to business B a price at which business B ought to tender in return for business A refraining from tendering. And again, the aim there is to keep prices artificially high. Bidding on unacceptable terms, conflicts of interest, and again, those can take many forms, as we'll see later on. Conflicts both between bidder and authority, and between a bidder's bid team and its other functions. Its functions concentrating on delivering business as usual. There could be cross-fertilization there, which skews a bid and a bid process. Inducements, bribery basically, more on that later, and canvassing. Canvassing officials at a contracting authority. Lowballing, abnormally low tendering with a view to raising prices if and when a contract is awarded, as the lowballer hopes it will be, to it. Non-transparent appointment of subcontractors can also be a source of, or a route in for corruption, and supply chain members. Procurement, of course, fraud and corruption doesn't, of course, go away when the procurement is complete. It can happen when it comes to direct awards or during the lifetime of a contract. And you can, again, package into the broad umbrella of corruption lack of justification for direct awards, or direct awards which have potentially been tainted by some sort of influence, some sort of undue influence. A lack of transparency generally when it comes to awarding directly without a procurement process. Lack of new procurements following some unjustifiable substantial modifications is, I suppose, another manifestation of underhand behavior in procurement, and also from bidders or from businesses overcharging or charging for work that hasn't ultimately been done. So again, the importance there is seen of having really good contractual mechanisms for ensuring that only work that is done and done properly is paid for. I'm going to hand over now, having set the context, to the first of our subtopics, grounds for exclusion in procurement, and what the regime itself has to say about rooting out fraud and corruption there. And Simon's going to take us now through some of that.
Great, thank you, Chris. So my first topic for today is to talk through the relevant grounds for exclusion. So this is all on the basis of what is in the current set of procurement rules, the Public Contracts Regulations 2015. They are set to change over the next year or so through the Procurement Bill, and we'll touch on that later, what the effect of that will be in the context of fraud and corruption. So Regulation 57 of the Public Contracts Regulations is the key piece of legislation when looking at fraud and corruption, and also mandatory grounds for exclusion and discretionary grounds for exclusion. So it's quite a lengthy and detailed regulation, and it's sometimes quite difficult to read. In the past, we have had to instruct counsel on interpreting one of the mandatory exclusion grounds, so it can be quite complicated. So the first type of exclusion ground is mandatory. So that's where if any ground is present, then the supplier has to be excluded. This is subject to what's called self-cleaning. So mandatory grounds for exclusion, they include a conviction for conspiracy, corruption, so abuse of a position of power to gain undue influence, bribery, money laundering, and various offences relating to the proceeds for criminal activity. So the list on screen is not an exhaustive list, and Regulation 57 should be referred to if you want a full list of every mandatory ground. Another mandatory ground is for non-payment of taxes or social security contributions. However, this is only mandatory where the breach has been established by what's called an actual decision that has final and binding effect. So if the supplier has breached tax or social security obligations, but the supplier has not been convicted, then the exclusion ground is not mandatory, but discretionary. The third point there, the exercise of discretion has to be reasonable and proportionate. So an authority can't just decide on a whim to exclude a bidder from a procurement, and it has to consider everything in the round and whether it's reasonable and proportionate to do so. There are specific time limits for exclusion under Regulation 57 of the PCR. So for mandatory grounds, this is 5 years from the date of conviction. Related points, self-cleaning. So this is set out in Regulations 57, subsection 13 to 17. Essentially, a supplier cannot be excluded where they've demonstrated self-cleaning and their reliability, taking into account the gravity of the offence and the circumstances. So the supplier needs to demonstrate that it's done 3 things in order to gain the benefit of self-cleaning and not be excluded from a procurement. So firstly, that it's paid compensation. Secondly, that the supplier has clarified the facts that gave rise to the exclusion ground, collaborating with the relevant investigation authorities. And lastly, that it's taken what's called concrete, technical, organisational and personnel measures that are appropriate to prevent further offences from happening. So quite a detailed set of principles that a supplier has to do in order to gain the benefit of self-cleaning. Lastly, just a note there, Procurement Policy Note 0421 contains quite a lot of guidance around conflicts of interests, exclusion grounds, and also whistleblowing. So it's worth looking at that if you want more information about when the mandatory grounds apply. So just moving on to discretionary grounds. Discretionary grounds are generally less serious misdemeanours that do not give rise to a mandatory ground. And these are also set out in Regulation 57. So these include breaches of environmental law, social and labour law, what's called grave professional misconduct, anti-competitive behaviour, and, for example, obtaining confidential information that will be used to the supplier's advantage. For discretionary grounds, the time limit for exclusion is 3 years from the date of conduct in question. The exception to this is that if the discretionary ground involves a criminal offence, so for example, bid rigging, then it runs 3 years from the date of conviction and not from the date of act itself. So the third point there, fraud, that used to be a mandatory exclusion ground, but it now seems to fall within a discretionary ground due to Procurement Policy Note 0421. And we think that it falls within the definition of grave professional misconduct that renders a supplier's integrity in question. The fourth point there, note the Crown Commercial Services Standard Selection Questionnaire. There is the ability in there for suppliers to self-declare that the exclusion grounds do not apply to them. However, this relies on the trustworthiness and honesty on the part of the supplier. There is a process in Regulation 59 of the PCR where an authority can verify the evidence that the supplier has submitted prior to award. So again, we recommend that an authority does this. There are carve-outs in Regulation 59. So if the information is publicly available on a national database, then the authority can't request this from a supplier. And again, just a note to Procurement Policy Note 0421. Just moving on to the next topic of conflicts of interest, which are related to fraud and corruption. So an authority has a duty under Regulation 18 of the PCR to ensure that bidders in a similar position are treated in the same way and subject to the same conditions unless there is an objective justification for doing otherwise. So there was a paper from the Procurement Lawyers Association in 2019 that sets out quite a lot of background to conflicts of interest and the relevant case law. We won't be going into the background to this for the purposes of this presentation, as the topic of conflicts of interest may be a topic in itself for a future ThinkHouse session. So we're going to go through some of the high-level principles that derive from the case law. So firstly, to categorise the different types of conflicts of interest, they can arise in a wide range of situations. So the first type of conflict is an authority conflict. So during a procurement where an authority employee has personal connections or financial interest with a bidder. Secondly, a bidder conflict. So this is where one bidder is put in a better position compared to other bidders due to, for example, personal relationships, incumbency advantage, so if they're the current supplier of services, or if they have had prior involvement in planning for procurement as well. Lastly, corporate conflicts, possibly less common than the first two. So when one corporate parent company owns more than one bidder so that they have visibility across different bids from different suppliers. Procurement Policy Note 0421 goes into more detail around this type of conflict. So please refer to that if you want a bit more information about corporate conflicts specifically. So the next slide just demonstrates and categorises the different types of conflicts that may arise in a bit more detail. So the obvious one is personal conflicts. So for example, where a member of the authority team is married to someone from a bidding organisation. Next, internal conflicts. So where an evaluator or a moderator from the authority may be conflicted from working on a project due to their past experiences with a bidder. And lastly, professional conflicts. So it's a small world, especially in the legal world. So a professional conflict may exist where a person moves from the public sector to the private sector or vice versa, or has worked for a bidder previously. So that's something that we see quite a lot happening on the procurements that we advise on. And all of this needs to be considered against the risk of a procurement challenge. So if there is a procurement challenge, a bidder is likely to go for anything possible. So there needs to be a clear and transparent audit trail in place and a clear conflicts of interest policy that's been followed to ensure that an authority is protected. So last point around conflicts of interest. So what is the legal duty? This is set out in Regulation 24 of the PCR 2015. So the same set of regulations that we've looked at previously. So a contracting authority has to take appropriate measures to effectively prevent, identify and remedy conflicts of interest during the conduct of a procurement, to avoid any distortion of competition and to ensure equal treatment to all economic operators. So we'll pick up some of the key phrases from this definition. The PCR does not provide a complete list of conflicts of interest, and whether a conflict will exist will depend on the facts of the case and the circumstances that lead to the authority if they treat the supplier more or less favourably compared to another one. The third point there, a mere perception of a conflict is enough. So the key around conflicts is that it can just be a perception of a conflict of interest for an authority to have to prevent, identify and remedy that conflict from arising. So that's referred to an apparent bias. So the fourth point there, appropriate measures. So what does a contracting authority have to do to prevent, identify and remedy conflicts from arising? So again, there are no examples provided in Regulation 24. So we'll just touch on some of the examples that could be appropriate measures. So firstly, structural things that the authority can do. So information walls or ethical wall agreements to separate the bid team and the incumbent team from sharing information. That's quite a common one that we see. Secondly, declarations. So both internal, so from evaluators, moderators, everyone involved in the procurement at the start of the procurement, and external, that a conflict does not exist through a conflicts of interest policy. But again, that's quite likely to rely on the party's trustworthiness in declaring whether a conflict arises or not. Thirdly, undertakings to declare future conflict situations. Fourthly, an independent oversight body to monitor what the authority does day to day. What other appropriate measures are there? So if an evaluator is working on the current contract where the incumbent provider is bidding again, an authority could ensure that bids are redacted so that they don't see who is submitting the bid, and they can't establish who the incumbent is from what's been provided. However, in practice, this may be quite difficult, especially if the evaluator who's working on the current contract may still be able to identify who the parties are from their own experience of that provider. Lastly, it may be possible that a conflict cannot be remedied, and it may be that an individual from the authority cannot be involved in a procurement due to their conflict of interest. So lastly, on this point, a procurement may take a number of years to run, depending on the type of procedure that the authority uses, and especially whether there's negotiation involved. So it's important that these appropriate measures that an authority uses to prevent, identify and remedy conflicts are reviewed at key milestones throughout the procurement. For example, from the market engagement stage to selection questionnaire stage and the tender stage, and where there's a turnover of staff, so that the authority can monitor conflicts right throughout the procurement and have a clear audit trail in place at the end. And on that, I'll hand back to Chris to talk through bribery.
Simon, before I do, just to note, by the way, that you'll have noticed that in this session, some of the text on the slides is in blue and is underlined. That's because those are links which will take you straight to the relevant resources. So when you receive the slides, they will contain links which will simply take you straight through to the resources to which the link refers, just to save any issues having to try and go elsewhere for the materials. Okay, a quick word on bribery. Not planning to say much about this other than to remind you that it's a ground for mandatory exclusion in the PCR under Regulation 57.1c and 57.1d, which are there. Corruption is also listed, although that's really now subsumed within the Bribery Act itself. And just to bear in mind as well that there are more than one bribery offence. There is obviously bribing another person, but then there is also being bribed, so accepting a bribe from a bidder, for example, Section 2. And bribing a foreign public official, Section 6. Now, actually, those three offences are captured in Regulation 57.1d as the offences which give ground for mandatory exclusion. There is, in fact, another another bribery offence, the Section 7 offence, which is failure by a commercial organisation to prevent bribery, not listed in D as one of the 3 offences giving rise to mandatory exclusion, but one could perhaps take the view that that could at least give rise to a discretion to exclude by virtue of the fact, for example, falling into a wider gross professional misconduct umbrella. Procurement Policy Note 0421 again gives more insight into this. So that was all I was planning to say about this now. And instead, I thought I'd move on to sanctions, talk a little bit about those. And again, the link is here to Procurement Policy Note 0122. Obviously, that was published at the end of February last year, and concerns contracting with suppliers from Russia and Belarus. It applies, strictly speaking, to central government, but in fact, all public bodies are urged to follow it. Now, it's important, I think, just to be aware of what this procurement policy note doesn't advocate as well as what it does. Because the thrust of it is that authorities should consider terminating contracts with a Russian or Belarusian prime contractor in accordance with its terms. So not on a whim, but only in accordance with the terms of the contract in question. And not only that, but authorities are also urged only to proceed actually to terminate if an alternative supplier can be sourced in line with value for money and affordability considerations and with minimal disruption to public services. The PPN also, I guess in this context, urges authorities to make sure that they have a proportionate and risk-based approach to reviewing their contract portfolio for such contracts. Now, this is obviously going to be more relevant to some authorities with larger contracts, perhaps with an international supplier base or with a supply chain straddles continents, than to others. But it is there, obviously, as guidance in that particular context. A distinction, too, is made between, I suppose, ordinary contracts and volume-based contracts. For example, or maybe even perhaps frameworks or panels of frameworks where, frameworks of panels of suppliers where perhaps the PPN might capture some suppliers but not others. For volume-based contracts, a reduction in volume to 0 could achieve the same effect if termination is not feasible. So if, for example, one has a framework and there is a contractor on it who is Russian or has a Russian supply chain or whatever, then the safest way of dealing with that might simply be not to place any work with that particular supplier, but to go to others on the framework. And also the following is worth noting. We've picked this out because I think it's particularly important. The public sector's exposure to these suppliers is primarily limited to the energy markets, where there have been significant price fluctuations and the market is considered volatile. You must seek advice from an energy expert and or relevant organization before taking action to terminate an existing energy supply contract to ensure an alternative source of supply is available and also affordable. So again, it points here to the fact that most issues of this type are likely to come into play when we're dealing with energy supply contracts than perhaps other types of contracts. So the need to deal with this or to act on the PPN might be quite limited, but where it happens, that's where it's most likely to arise. There's another collection here of comments from the PPN, which are of note, and I think which are useful because they tell us what to do or what perhaps what we should be looking at when we're running a new procurement. We're not, for example, terminating the existing contract. So regarding new procurements, you could decline to consider or otherwise exclude from participating bids from suppliers who are constituted or organized under the rules or the laws of those countries, or where there are persons of significant control indicating Russia or Belarus as the place of residency, unless the supplier or supply chain member is registered in the UK or in a country the UK has a relevant international agreement with reciprocal rights of access to public procurement, and or has significant business operations in the UK or in a treaty state, if you like, a country with whom the UK has a relevant international agreement. So care is needed in those situations. Because if either of those criteria apply, then the supplier in question shouldn't automatically be excluded from taking part in a new procurement, because let's not forget, we have equal treatment, non-discrimination, etc. provisions in the regulations to think about. Now, sometimes, of course, a supplier or a supply chain might have a much more complex structure behind it. And where that is the case, where there is a more complex group structure involving parent or group companies based in or operating in the UK or in a reciprocal agreement country, you should consider the specific circumstances and take legal advice where appropriate. So the key message here is don't just exclude or indeed terminate on a whim. Think very carefully about the setup and about how lawfully and validly to approach it without breaching the relevant procurement principles or rules. Just to say something now, again, not much on procurement during the pandemic, if only really because it brought up, it threw into relief some interesting, I suppose, examples around, perhaps the potential for corruption or the potential for underhand behaviour to be seen in the context of a situation where things needed to happen very quickly and things weren't always predictable. So the early response to the pandemic, which is when actually most of what I'm about to talk about actually took place, brought with it quite a lot of direct awards and unplanned contract variations, because obviously there was a situation of extreme urgency, which, let's face it, necessitated quite a lot of deft movement when it came to procuring goods and services. So goods and services sourced on that basis included ventilators, test kits and testing services, laboratory swab analysis services, and of course, as we've all heard about, PPE. Now, of interest here is that situation, that whole situation, as was inevitable, led to fewer of the normal checks and balances that you would ordinarily expect to see in public procurement, and which are aimed at keeping procurement transparent and auditable. And so as part of all this, and again, some of this kind of surfaced later, as we know, there were allegations of awards to companies which were, for example, claimed to have little or no relevant experience in the relevant sectors, or to have certain connections to particular individuals. And this, I suppose, it really just underlines why transparency in this sort of situation remains key. So the principle of transparency does apply even where we have a direct award. It applies generally, the general rule that applies in procurement. Why is that? It is so that there is visibility of what has been awarded. Now, it just so happened that there was also here a legal challenge to a lack of publication of contract award notices. So it's a requirement that contract award notices are published. And there was some of those were missing, and so there was a legal challenge there. And I suppose on the back of all this, in response to that rather interesting sort of set of circumstances, we thought we'd just gather together all of the various tools in the procurement regime that exist in order to allow authorities to be transparent. So in particular, Procurement Policy Note 0123, Procurement Policy Note 0121, which is procurement in an emergency, the public contract regulations, various parts of those, regulations 48 on prior information notices, which can be really important as a transparency tool, contract notices, clearly advertising the contract, contract award notices and modification notices, notices under regulation 75 for advertising contracts which are procured under the so-called light touch regime. And very importantly, and perhaps these are a couple that may sometimes get overlooked, Regulation 83, which expressly requires contract copies to be retained, and Regulation 84, which requires systematic reports of all decisions made in the context of a procurement process. Quite often we find authorities saying to us, well, do we need a Regulation 84 report? What is a Regulation 84 report? Well, it's a running report of all decisions that you make, really before, during, and after a procurement process, because when there's a legal challenge, it's not unheard of for the challenger to request disclosure of a Regulation 84 report. And it's not great if one doesn't exist. Regulation 99, again, really important when it comes to direct awards, because this talks about this covers the use of voluntary transparency notices as a protection against ineffectiveness. And again, low value, below threshold procurements, those are dealt with in Part 4, and even there are certain requirements for publication and transparency. So there are lots and lots of provisions in the regulations which are aimed at transparency. And we would just, in the case of VEETs, refer you to the case of Faraday in West Berkshire, which is mentioned at the bottom there, and which urges VEET notices under Regulation 99 to contain plenty of information so that what you're proposing to do as an authority is very, very plain to see. Yes, so the Procurement Bill, as I'm sure we all know about, introduced in 2022, has quite a lot in common with the public contracts regulations as regards provisions which are designed to root out fraud and corruption. However, it arguably goes even further. Now, there are some differences in terms of how transparency in particular and exclusion are handled in the bill. And we'll find out more about that when we come to talk about the bill in another session. But there are a number of provisions which are aimed at really rooting out fraud and corruption in various forms, and they're all on this slide. So we have similar provisions, rather similar to Regulation 57, which are aimed at excluding suppliers from award processes. Where it goes further is Regulation 28, which specifically talks about excluding suppliers by reference to subcontractors, and 29 on excluding a supplier that represents a threat to national security. So that is a little bit different, and indeed a bit of a build on what we currently have. Regulation 31 is also another example of the bill going a little bit further than what we have at the moment, because that talks about procurement processes which are modified mid-process, so not modifications to sign contracts, but modifications during the course of a procurement process. Because again, that's another potential opportunity for corruption to creep in. 57 and 58 and 59, 65 again are about excluding suppliers, and also they cover these cover debarment. So in other words, having suppliers on debarment lists or lists of excluded suppliers. 104 to 106 are those deal with investigations and oversight, and Schedule 6 and 7 rather similar to Regulation 57 1 and 57 8 set out the mandatory and discretionary exclusion grounds respectively. Also in the bill, the other half of this is that the bill is very, very big on transparency. It's big on being transparent about what is about to happen or what is happening during the procurement process. And this is a very long list of notices which the bill makes provision for in relation to transparency at lots of different stages of a procurement process, and indeed transparency for lots of different types of procurement route. And there's a transparency notice for pretty much everything. Some of those map across to PINs and contract notices that we have, and VEETs, for example, in the current regime, but there are new notices which go further, like contract details notices, contract termination notices, and so on and so forth, and even pipeline notices. So all of that will be worth getting to grips with when the bill nears its implementation. So I really will hand over this time to Simon to talk about tools for rooting out mischief in procurement. So the stuff you can do on the ground and in real time, as it were, to help root out fraud and corruption in the process. Simon.
Great, thank you, Chris. Yeah, transparency is probably the key word from the procurement bill, and yeah, it'll be interesting to see how all those notices work out once the bill develops. So we're just going to cover now some of the tools to help root out fraud and corruption, and we've split the next few slides into three broad topics. So the first of those is legislative tools, the second is bid stage tools, and lastly behavioural tools. So the first of those, legislative tools, so we've touched on quite a few of these already, but to recap, this is all set out in the PCR 2015. So Regulation 18, the key principle that authorities have to abide by on equal treatment, non-discrimination, transparency and proportionality, that really goes to the heart of a procurement and preventing fraud and corruption. Some of the other ones that we haven't mentioned, Regulation 22, that's quite a detailed regulation as well, and it sets out the rules applicable to communication, so both written and oral communication. Regulation 40 and 41, they're quite linked well, So 40 that goes into preliminary market engagement, and 41 goes into prior involvement of suppliers. 67 that talks about award criteria, especially the current regime of the most economically advantageous tender. 69 talks about abnormally low tenders, and as Chris went through in quite a lot of detail, Regulation 84, the Regulation 84 report that an authority has to draw up at the conclusion of a procurement is something that we see authorities miss quite a lot. So again, once you get to the end of a procurement, make sure you do a Regulation 84 report. Some of the other key points there, we've listed out some more procurement policy notes that fall into the category of legislative tools to help prevent fraud and corruption. Some of the other ones, so statutory guidance on the use of standstill letters. So the process for sending standstill letters is key to transparency. And there's a guidance note that we've included a link to there. Wider public scrutiny. So for example, the National Audit Office and its role in monitoring government spend and ensuring value for money. They produce quite a number of reports looking at government spend, and again, that goes back to helping rooting out fraud and corruption specifically. So the next set of tools are what we call bid stage tools. So the first step is generally the selection questionnaire stage. So an authority can root out fraud and corruption through a thorough evaluation of SQ responses. We've mentioned tenderers' declarations and undertakings. Some more points here, conflicts of interest declarations, both internal and external. Some of the points that we haven't mentioned, rigorousness around reports, so ensuring that everything's documented, in particular all decisions made during the procurement, again going back to the requirement for a Regulation 84 report. Something slightly different, so once you're actually in contract, what can you do to obtain necessary key data from the incumbent for use in the re-procurement? So information on staff, turnover, trends, data, all of this goes to helping the authority model the next contract and procurement, and gives all bidders an opportunity and a real picture of what's going to be in scope of the procurement. So anything to do with the service currently that might help all bidders price for the re-procurement or understand whether to bid or not to bid, it's really important that an authority gains that information. And you'll see perhaps obligations in the contract for the incumbent provider to assist on re-tendering. There are model clauses in the model services contract which help with this. So again, this point goes back to the principle of ensuring a level playing field between all bidders so that they've all got the same opportunity for the new contract. And lastly, there clear and rigorous provisions in the contract around audit, price transparency, and avoiding and managing conflicts of interest throughout the procurement itself, and rights to inspect the current contract as well. So again, some more bid stage tools. So what are the things to look out for at bid stage? So firstly, if there are unexpectedly few suppliers actually tendering, especially if the market engagement events drew quite a lot of interest, that might be something which leads an authority to think that something's wrong. Third point there, looking for any identical or very similar passages or statements in competing bids, or if all bids are priced unexpectedly high. Another interesting point, so look for instances of where a supplier is appointed to a framework, but then doesn't want to work or doesn't want to go through a mini competition process. One of the other points is around market engagement. So for an authority to ensure that where there is market engagement and suppliers can talk face to face, that there's possibly a clear protocol in place, again, to try and limit the opportunities for fraud and corruption. Again, sometimes that's easier in practice through Zoom or Teams. And the last point there, never tip a supplier off if mischief is suspected. And the last set of tools, behavioural tools. So the first point there, clear defining of procedures and roles for those involved in the procurement process and those who feed information into it. So everyone's clear at the outset what they have to do. A stream of consciousness, so ensuring that anti-corruption and alertness to its signs are part of the ethos of an authority. And the third point there, training of evaluators, not only in the art of evaluation, but also in spotting the signs of fraud and corruption. So just conscious of time, I'm just going to talk for a minute or so about the Procurement Bill itself. The Cabinet Office release an update on the Procurement Bill at the end of each month, and we recommend signing up to this update. The latest update from February confirms that the bill has passed through the committee stage in the House of Commons, so it's progressing well and is now in the report stage. Once the report stage has passed, there'll be a third reading in the House of Commons and then a final stage consideration of amendments. The Cabinet Office, in their latest update, they anticipate receiving royal assent for the bill later this spring, and then there'll be work to finalise secondary legislation, so statutory instruments or other regulations. There'll then be a public consultation on the draft regulations, and more detail will be shared around this closer to the time. The Cabinet Office do expect the earliest go live for the Procurement Act to be spring 2024 at the earliest, and there will be a 6-month implementation period to bring everyone up to speed on the new regime. So we'll keep you up to date on what's going to be changing in the Procurement Bill, and it's likely to be the topic of a future ThinkHouse, either in person or by a webinar as well. So we'll keep you up to date on that.
Thanks very much, Simon, for that. In view of time now, we'll probably pick up any questions offline, respond to those offline. But in the meantime, thank you very much indeed, everyone, for attending this morning. A couple of dates for your diaries. We have webinars planned, future webinars in this series for the 6th of June, and also the 12th of September. Topics to be notified. So do please make sure that you're signed up for those. Likewise, Simon and I are here if you've got any questions which occur to you on this topic after today. And we look forward on that basis to seeing you all again very soon. Thanks very much indeed, everyone.
Thank you.